please the court, Erin Rockenbach on behalf of Citizens Property Insurance Corporation. I'd like to reserve 3 minutes for rebuttal.
Okay.
The simplest error in this trial occurred when the jurors were converted into scientists or engineers as opposed to fact finders choosing the best engineer with the most qualifications and the plan to fix this property. This error of a hybrid verdict form, which combined the two experts' plans, if you will, was compounded by the error in the jury instructions and the verdict form, which mixed a breach of contract with a declaratory judgment action. And this predictable result really is based on the beginnings of this lawsuit, which is the core question that this court has to answer.
Remind me, were there any objections to the verdict form?
Oh, yes, Your Honor. There were actually 3 charges.
Because that wasn't raised as an issue on appeal.
Well, the issue is really on the issues 3 and I think it's 2 and 3. 2 and 3, which are the jury instructions and the verdict form that were legally flawed.
Because I remember the argument on the instructions. I don't recall there being specifics as to the verdict form itself was deficient.
Okay. Well, and I guess the issue to the verdict form goes to the very first issue on appeal, which is whether citizens could ever be in breach of contract when, in fact, citizens followed the Sinkhole law to a T and the plaintiff filed a breach of contract action before entering into a repair contract.
So what is it you want your insureds to do? If they report a sinkhole and you say, yes, indeed, it's a sinkhole, and then we get into the unfortunate divide of forensic engineers where yours wants to do the cheap repair and theirs wants to do the expensive repair, what's supposed to happen at that point in time?
Well, legally, for a breach to be a viable breach of contract action,
I'm not talking about breach. I'm just
in a
you
practical,
got a dispute
in a
there.
practical world, the insured has 2 options. When there's a dispute before they file, in this case, before he filed his breach of contract action, he had options. He had the option of going to neutral evaluation for free because there's a disagreement. You could go for a tiebreaker, and the insurance company will.
This went to neutral evaluation here, right?
Eventually, it did, yes, Your Honor.
Did that change anything?
It did not, but that was an option. The other option, Your Honor, is to file a declaratory relief action because
What's the difference between that and this?
Well, there's no difference in the terms of fees. My client would still pay fees if the insured prevails. That's not the issue. The goal of and the strategy behind filing a declaratory relief action is to repair the land. Because in a breach of contract action, logically, legally,
that would mean
it
that all
yields.
the stuff here about breach of contract is irrelevant because the jury answered the declaratory question about is it A or B, and they went, or maybe they went someplace in between.
They went someplace in between, which neither expert recommended, but also to the fact that it was not a pure declaratory relief action, which we offered and requested and were denied. It was mixed jury instructions. This verdict was flawed because of the fact that the jury was instructed on breach, and then there's a hybrid verdict form on breach and, as you indicated, pick a method of repair. But in this case,
Did citizens make it clear, by the way, that if you used a deck action, that if the insured got a better outcome, they would be entitled to 627, 428 fees?
I think the law is very clear on 627.428, and it says judgment or decree in favor of the named insured. They would get a fee. My client would not take the position, nor would I ever, that they don't get a fee.
Okay.
The point of the declaratory relief action, the strategy behind it, is to fix the land. As a matter of public policy, that's what the sinkhole statutes want. That's why the condition precedent is parallel in both our policy and the statute, that you have to enter into a repair contract in order to get money. We don't want to write a check. And the goal of the declaratory relief action, which we asked this judge, I want to say in 2013, I think it was June, July.
This action, maybe I'm confused, but at the end, after the jury verdict, citizen still doesn't have to pay for repairs unless there's a contract, right?
That's correct. She did enter a final judgment, but the final judgment's interesting, Your Honor, because it says that the judgment shall not be payable until they enter into a contract per Mr. Galati, per the jury verdict. So let's get back to that flaw in the jury verdict. What the judge did here was essentially give an engineering license to 6 lay people who were supposed to be fact finders, choosing one method of repair, one expert.
Well, let me ask you about that, because the jury instructions themselves were pretty clear. If you find the citizen's expert recommendations provide necessary stabilization and repair, your verdict is for the defendant. If you find otherwise, your verdict is for the plaintiff. So that's a pretty clear instruction. So what you're arguing is once you get the final verdict, it seems to me you're arguing it's inconsistent. But there was no objection as to an inconsistent verdict.
Well, there was in the charge conference, Your Honor, because citizens wanted.
But did you object to the verdict and allow the jury to go back and be re-instructed or anything?
Oh, no, because the verdict form was set based on a charge conference with the trial judge. Citizens filed their requested jury verdict, and there were several forms. But the final form that we filed, I think it was January 14th, no, it was before January 14th, obviously. But the final verdict form that citizens requested was choose this expert or that expert. What the jury here did was pick two forms, two repair methods. They picked the compaction grouting from the plaintiff's expert, and then they followed the statutory engaged engineer who said no underpinning. No engineer recommended this particular fix for this property.
It's not that rare for juries to listen to two forensic experts and decide that the mid-ground is where the truth lies.
Understood, but this is really a science issue. And it's analogous to
Most times when we have experts, it's
forensic, it's science. But it's analogous to two doctors, Dr. A saying, well, I recommend amputation below the knee. Dr. B says, no amputation whatsoever. And the jury comes back and says, well, just amputate the foot.
Okay.
That's really what they did here. They devised a method of repair, and they don't have the authority to do that.
They have the authority to believe or disbelieve or agree to part or reject all of an expert's testimony, and you agree to that instruction. That's given every civil case.
That's a standard,
And
yes.
it looks like that's what they did.
But they devised a plan to repair the land that neither expert recommended.
But it sounds like
So they picked part of one and part of another
And I
expert.
guess harmful to your client as opposed to the homeowner. They want the home fixed and they want the sinkhole fixed.
Right, we do want the sinkhole fixed,
So
but we want it,
Assuming you're correct, that we should reject what the jury concluded, how's your client harmed by that?
my client is harmed, well, for.
I mean, you have to establish harmful reversal error.
Right, well, for multiple reasons, and the first and most basic core reason in this appeal is that there's no breach. Unlike the.
No breach because they didn't sign the contract.
Exactly.
And where did you raise that as an affirmative defense?
Well, in the second affirmative defense.
And what does that second affirmative defense state?
It cites 627.707, the
And then it
statute that
says,
requires.
specifically to the extent coverage would be determined to be available under the subject policy, any payment would be subject to being as incurred. That
Right.
seems to me to be the specific defense that's raised.
It is, and the fact that we have.
Was it ever raised that they failed to meet the condition precedent of entering into a contract?
Absolutely. On the
Where?
motion for a directed verdict, we
Where in
argued-
your affirmative defenses?
Well, it's the second affirmative defense that you
Read,
just.
read the language
you
to me
cited.
where you say they failed to enter into a contract
Contract.
before
It-
they
it's-
filed suit.
It only cites the statute, and that argument was.
And there are multiple conditions precedent in both the policy and the statute.
That's correct.
So how is it specifically raised, which is your obligation to raise on the defense?
It was tried before the trial judge. It was raised specifically in the
The
context of
trial
that.
judge was never told that that was an issue, was he?
Actually, she was.
At the
And
pretrial conference where the statements the parties agreed to as far as what was going to be tried, was that in there?
in the pretrial order there, and that was raised as an issue on appeal by the appellee. In the pretrial order, the issue of breach is raised in the pretrial order.
But that's not my question.
It doesn't say no repair contract, Your Honor. No, it does not.
So when was the trial court or the other side put on notice that this specific defense was what your client was going to rely on?
A failure to enter into a repair contract. There was a summary judgment motion, and I believe that it was based on the claims presumption that they didn't share a contrary report before filing suit against us.
So again,
But the
it had
first
nothing to
time
do
would
with
have been
It had nothing to do with the entry into the contract.
contract. It would have been at the directed verdict stage, at
Isn't
the
that
directed
too
verdict motion. I'm sorry?
Isn't that too late?
No, Your Honor, because the essential elements for breach of contract action are the plaintiff's burden of proof. I don't have the burden to prove.
The plaintiff doesn't have to prove every condition precedent, does it?
No, not every
In
condition
fact, the
precedent.
plaintiff doesn't have to do it unless it's raised.
Absolutely.
And the
with
rule
specificity.
says that it has to be specifically raised.
Yeah, absolutely. That's the rule of civil procedure. I agree. What I'm getting to is the breach issue. We can't be in breach if they haven't satisfied the requirements for breach.
Can I
How-
ask a couple of questions?
Sure, yes, sir.
Number one on breach, is the judgment that is the result of this verdict going to require you to pay more money than you would pay under the contract, so to speak?
Will it require me to pay
Yeah,
more
are you-
money than under the?
Are you going to be paying money in excess of what the coverage was?
I don't know. Based on the verdict form, it was an amount of compaction grouting. It wasn't a dollar sign, as it should have been in a breach.
I guess I'm going back to, I don't know
But-
that whether this is a breach or not a breach makes any difference if this was what you would pay pursuant to the contract
Right.
as compared to, some bad faith theory above.
Right, it's not, I don't know that it's an extra contractual issue.
It seems to me that they may have just actually bitten off a harder case to try than what they needed to, because they didn't need to prove breach, they just needed to prove what you needed to do for performance under the contract.
Well, I think they did need to prove breach, because that was their cause of action that they
You just told me we could do
chose.
this as a deck action.
We could have, but we were denied. Plaintiff objected, adamantly objected.
So they
Citizens
put a greater
offered.
burden on themselves.
Correct, to prove a
Inside
breach.
their breach, we tried a deck action. And that leads me, I guess, to my second question, which is you're claiming that the jury decided to cut off the foot rather than leave it alone or cut at the knee,
Right.
but they picked one of two options on the verdict form. They didn't come up with their own option here. So I don't quite understand how it is that the jury's doing this if it's on the verdict form.
Okay. Well, question number 5 is 1 and 2, subparagraphs. The jury didn't pick one expert. What happens in the sinkhole statutes is that an expert certifies. The expert who finds sinkhole certifies the necessary repair method. In this case, SDII, the statutory engineer, said 15 feet below surface, compaction grouting. That's all he opined. It's all he certified that was necessary to repair. Sonny Galati of FTE came in and said more grout, 10 feet below, plus underpinnings. When it got broken down into the verdict form, which was objected to, and citizens absolutely requested actually money damages at one point because it is a breach of contract action. We wanted money damages, and then we wanted and filed a motion to enforce sinkhole statute consistent with this court's McKee decision that would require repair contract. Really, if the plaintiff chooses a method of, or chooses his cause of action and seeks a breach, it's logically a damages issue. That's a damages case. You get a money line on the verdict form, and then what?
So you ended up with a verdict form that's just the deck action you asked for to begin with.
But it's a hybrid. The verdict form is a hybrid in 2 ways.
I don't understand how it's a hybrid. They were asked
Okay.
to pick one or the other, and they picked it. Is 5 inconsistent with answers above it? Is that what you're saying?
Well, it's inconsistent with what the experts testified to, because no expert testified to what this verdict says must be done.
So why is A on the verdict form if nobody testified to this?
A is. What FTE testified to was 1A and 2. That was his combined testimony. Mr. Galati never testified that the necessary repair for this land was 10 feet below compaction grouting. That's not his testimony. His testimony is 10 feet below plus underpinnings.
So how does 1A get on the verdict form if nobody testified to this?
Because the court allowed or ruled that is how, this is how the charge conference and the verdict form got developed. But what is also problematic.
Can I ask another question? This may be stupid.
Yes, no.
I don't understand. Is compaction to 10 feet more expensive than compaction to 15 feet?
Yes, because 10 feet below the surface is higher. 15 feet below the surface would be 5 feet less
up
compaction.
To that level, not down
Right.
to that level, but up to that
I
level.
struggled with that
All
too.
right.
In every one of these, I struggled with the 10 feet below 15 feet.
But let
So
me follow
it
up
is
on
lower.
that part of it, though, because, again, it seems that this verdict form potentially is to the disadvantage of the appellees, because they didn't get everything their expert asked for.
Well, that's true. And actually, more importantly, they didn't get a necessary fix for this land. Nobody said, no expert testified that what the jury found was necessary fix for this land. They're only getting a partial fix based on their expert.
But they're not appealing.
I understand that, but we're appealing, saying that this is inconsistent with the
Well,
testimony
it's interesting
below.
because the instructions appear to indicate that if the jury believes their expert, this is how you should vote.
Right,
And if they believe your expert, this is how they should vote.
right,
And the verdict form is this hybrid.
correct, it is
And
a hybrid.
so I go back to what I asked at the very beginning.
Okay.
Was the specific language that you're complaining about now the subject of an objection?
Absolutely. In the charge conference, I want to say it's page 877 of volume 6. My best recollection is that that is where the charge conference, and there were 3 charge conferences, I believe, in this case. The judge really struggled with the instructions. You'll see the frustration below. One of the instructions that was legal error that
Was there a specific objection saying, Judge, you can't split it up this way because we've already agreed, or you've already told us you're going to instruct if you find their experts credible, this is how you have to vote. You can't give them those choices.
I know that there were objections, Your Honor, and I can't say
I know there were lots of
specific-
objections.
Okay, but I know there was an objection on the basis because citizens filed a request for a money judgment line. And our intent was, we do the money judgment line because you chose the breach of contract action, then we're going to file a motion to enforce Florida statutes consistent with this court's McKee decision. You have to enter into a repair contract. We can hold back until you actually hit that condition and enter into the repair contract. So to answer your question
Which of course
about,
raises yet another question, which is if the jury comes back with some verdict number and there isn't a contractor out there that will perform the work for that verdict number.
that's the problem that we have with this verdict, though, Your Honor. What contractor will perform a repair that neither expert has supported? Neither expert has certified that this repair that this jury verdict is found based on is the necessary repair method. So you've got to find a contractor out there, and maybe there is one, but this isn't what
Which again seems to be an objection or an argument that the other side should be making on an appeal or a cross appeal, but they're not. So I guess I'm still sort of puzzled by how your client is harmed by all of this.
Because it's legally improper. It's legally improper from the word go when they file a breach of contract action without entering into any repair contract.
And which your client didn't appropriately raise, so that's out the window.
Okay, and
Well, let me just mention this, because it just seems to me the underlying argument is that the insurance companies in these sinkhole cases do not believe that the issue of method of repair is ever a jury question, first. Secondly, Citizens was presented with a contract by this plaintiff before trial, and they rejected it.
it was within 2 years of filing,
Still,
after 2
it's
years of
before
filing the
trial,
lawsuit.
and they rejected it. So how can you say that this jury verdict is unfair or invalid or improper when your client's decision caused them to go to trial?
The problem is, and thank you for that question, because I think it highlights the McKee decision, and Your Honor wrote that opinion.
But that triggers payment.
Absolutely, if we deny the claim, and that's what you wrote in McKee. In this case, it was not a denial. This was, before suit, we said, we are going to follow the law. There's a sinkhole here. We have a statutory engineer.
Yeah, but you reiterated that they have to enter into a contract in accordance with the recommendations of your engineer, and that's not what the statute says, and it's not what the policy says, but your client persisted in that.
Okay.
That's why we have a jury deciding that.
And your point, Your Honor, is that we actually breached 2 years into the lawsuit when they provide us a contract consistent with their expert.
They did exactly what you wanted them to do.
But that would be an anticipatory breach of contract action. They would get to file a 2011 breach of contract action saying, I know Citizens is going to deny this claim when I send them my contract 2 years from now after we've litigated for 2 years. That's analogous to somebody, an insured here in Hillsborough County, saying, we're about to hit hurricane season, and I know State Farm or Citizens or someone's going to deny my claim, so I'm going to file a lawsuit now. I'm going to get in line because I know after I call them and their phone banks are busy, they're going to deny my claim. There is no such thing as an anticipatory breach of contract action. So their 2013 contract that they send to us after 2 years of litigation does not cure the lack of the necessary requisite element of breach that had to exist when they filed their lawsuit.
Of course, had you raised it appropriately as an affirmative defense, there is case law that says the case could be abated pending fixing of the condition precedent, correct?
That's from this court, the Pena decision, but significantly in this Pena versus Citizens decision, you're correct, Your Honor, that was a fraud issue and there was a lack of a contract, and this court said, no, dismissal is far too harsh. The trial judge should abate it or dismiss it, let them enter into a contract. What's really significant about the Pena decision from this court is that this court said Citizens, in that case, did not establish that there was either no breach or no damages. We did establish a lack of breach at the time they filed the lawsuit. They can't cure the no breach with a contract 2 years into litigation. We asked that this, I'm running out of time.
We've asked you questions from all directions, and we're actually about at 20 minutes right now, but I will save you some rebuttal time, and if you need another 60 seconds without
you.
interruption here, we'll give it to you.
Okay, thank you very much.
All right. Mr. Klingon?
May it please the court, my name's Erin Klingon, I represent the Appellee, Michael Maluski.
So how did the jury come up with $15,500?
Your Honor, I believe that they listened to the testimony of Mr. Grimes about all of the rooms that he gave an estimate for, all of the elevations that he gave an estimate for, and determined that the actual cash value of the loss or the replacement cost value of the loss was that amount, in addition to what they already paid.
What evidence was there to support that amount?
The photographs at the time of the loss, which
was there any testimony to support the dollar amount?
Yes, Your Honor. Mr. Grimes testified as to the cost for each room, which they were able to reject or accept. They didn't have to pick his number. They test the...
But he acknowledged that his estimate was based on actual cash value, correct?
Yes, Your Honor. He did. No, I apologize. He did not do that. He acknowledged that his estimate was based on the replacement cost value and not the actual cash value of the loss. But that ignores some very important points that I need to make for the court before we go down this line, because the policy was breached before we filed suit. The defendant admitted that the damage to the front of the property was covered. In fact,
their letter, if I remember, used replacement value, not actual cash value as well?
Yes, sir. In addition to that, their breach of the payment for the above ground, it's a replacement cost value policy. So once they breach that above ground damages payment, my client's entitled to seek all the damages flowing from that. This court recently considered that exact argument, that you didn't present the actual cash value, in a case, Citizens Property Insurance Company versus Oni Jerez. It's it's case 2D14-897, and that case was affirmed, and that was affirmed on May 1st, and no motion for rehearing has been filed. So you can consider that in rendering your decision here today. But ultimately, we have a broad evidence rule. We put forward evidence of the damage as Mr. Grimes estimated it, and also in his testimony, he testified that he looked at the photographs and that Citizens' estimate was not accurate. But more importantly, Citizens admitted that its payment was not accurate. It admitted that the damage to the front of the property was covered under the policy, and that the policy required them to pay that money regardless of whether my client ever entered into a contract for subsurface repair. That payment was required. They admitted they failed to do that, and he went on, and the corporate representative went on to admit that they violated the Florida statute. I'm presupposing that Mrs. Rockenbach is going to get up here and make an offset argument that, well, they paid for a piece of damage they shouldn't have paid for in the back patio. However, they admitted that that was covered, and they never sent a letter saying that damage in the back patio is not covered. No one took the stand and said, well, we're never going to pay for that. I asked, well, why did you ask for it back? And he said, because it's covered. If it's covered, then it's due, and owing, regardless of whether my client ever enters into a contract for subsurface repair. So they admitted they breached, they admitted they knew that breach before they issued the payment, and that establishes the breach before we filed suit.
Help me out on a detail I don't know that I understand. Is there a requirement in the policy to enter into a contract for cosmetic damages before you get paid for that, or is that a small enough item that they just cut a check for that?
Absolutely. Let me answer your question. No, there is no requirement in the contract that you enter into a contract for subsurface repair before the actual cash value is due. It says that they will pay the actual cash value of the loss, and they can keep it at the actual cash value of the loss until you enter in a contract for subsurface repair.
I guess, but what I'm trying to find out is the payment method for cosmetic damages different than the payment method for subsurface repair?
Yes, sir. The payment method for cosmetic damages is they issue the actual cash value of the loss when they confirm coverage. And I asked the corporate...
Normally just then write a check to the homeowner and say, go find your nurseryman and plant plants or something?
Well, they issue the payment, and then they may do something else in the future. They may not. We'll never know. But that payment, the corporate representative admitted, is due within 90 days of confirming coverage pursuant to the lost payment provision. So it's due. I could go into the contract for subsurface repair. However, Your Honor wrote the opinion on Cook Insurance Company of North America, or Cook versus Insurance Company of North America, which is 652 Southern 2nd, 1154, where you stated that their failure to preserve a condition preceding argument in their in the pretrial conference order is a waiver of that, and I think that the courts acknowledged that also. In Hadusa Corporation versus Abre, the second DCA made it clear that with specificity means exactly that. So I'll just go on to an issue that wasn't discussed. It was error for the court to enter directed verdict in my favor before the plaintiff or the defendant's case in chief. That was error. However, that was harmless error.
That's on the cosmetic issue.
On the cosmetic issue, yes, Your Honor. There's a case called Williams versus Salem Free Will Baptist Church. In that case, it was also a case where the plaintiff moved for directed verdict at the close of their case in chief, and the defendant didn't object. The court pointed out that procedural irregularities to which objections are not made are waived. But it said you can overcome that waiver if you show that you were deprived of due process. The case law cited by the defendant in its reply points out that due process is violated when they don't have an opportunity to put forward their case. Due process requires notice and an opportunity to be heard, which the defendant had. They had the opportunity to call any witness they wanted to establish what the actual cash value of the loss was. In fact, they tried to do that. They called Thomas Fisher, stated he intended to testify as to the cost of the cosmetic repairs, but after I hired him, he was not allowed to testify in that regard. But before they closed their case, I suggested they should call the person who prepared the original estimate, Mr. Long, and you can see that argument at 3,315 to 3,316 of the record. So no matter which harmless error standard you apply in this case, there's a suggestion by the second DCA that the old standard would still apply. But either way, it can't be said that the error complained of contributed to the jury's verdict, because they didn't hear about the directed verdict until after the defendant put forward their evidence, moved to vacate the directed verdict, and the judge ruled again that there could be no reasonable inference or no reasonable evidence upon which a jury could legally render a verdict in favor of the defendant on that issue. That being said, the whole consultation with argument and breach argument is something that the defendant injected into the case. I gave an opening statement towards the two issues that we agreed to try: the proper appropriate repair method and the cost of the above ground repairs. I gave that opening statement, and then the defendant...
At pre-trial, is that how we reached?
Yes, Your Honor. If you look at the pre-trial conference order...
It has that in it. That's okay.
Yeah. There's...
Because it intrigues me that we go through in the verdict form when we find a breach, and then instead of awarding damages for breach of contract, we have a jury to decide what it was the carrier needs to do to perform the contract, which I don't think I've ever seen this before.
Well, what happened, Your Honor, was I gave an opening statement solely about the cost of repair and the proper method and manner of below ground repair and the cost of same, and the defendant got up, and despite its motions in limine to prohibit me from talking about in consultation and the way the statute works, it decided it wanted to argue to the jury its interpretation of the law, the same interpretation you hear in legal arguments, its interpretation of the policy, and when it was confined to what the judge interpreted the policy to mean, it's now crying foul, and we're here. I do want to talk about that consultation issue. We're talking about the policy, not the statute. I wholeheartedly believe that the Supreme Court in the Warfel decision meant what it said when it said, first, we note nothing in the Sinkhole statutory scheme applies in the litigation context. I believe that, and that's why I asked the judge to take out the reference to Florida law in that jury instruction, because ultimately we're talking about the policy. The statute is permissive. They don't have to hold back the payments. They don't have to do those things. They can choose to put that language in the policy, or they can choose not to. They chose to put the language in there, and when they chose to do it, they wrote the words in consultation, not with notice to. I'm just trying to anticipate it with notice to argument. Your Honor has already determined that the statute that we're talking about here doesn't apply retroactively in the Roker decision. And that's consistent with Florida law, because what could be more substantive than having the right to have a say in how your house is fixed? There's ample case law that stands for the proposition that even if a statutory change is a clarification, that it can't divest a party of a vested right, and that's exactly what would happen if you say with notice to applies retroactively. But that would require you to analyze what in consultation with means. And even if you accept the defendant's suggestion that the rules of statutory construction apply, they admit in their brief that it's not ambiguous. In their reply brief on page 7, they say those terms aren't ambiguous. If they're not ambiguous, you have to apply their plain meaning. The plain meaning of consultation is not, we're going to tell you and you're going to do it. Black's Law Dictionary defines consultation as asking someone's opinion or advice. So if you're going to look at what the statute means, I think that's the interpretation you should apply. However, I believe that even, since we're talking about the policy, if it's ambiguous, it has to be construed in our favor anyway. I wanted to answer a question that you did have for Mrs. Rockenbach regarding the levels of below ground repair. What happened was there was testimony regarding the loose near surface soils and how the loose near surface soils affect the stability of the home. Ultimately, under the contract, they have to do 3 things. They have to stabilize the land, stabilize the building, and repair the foundation. When you stop grouting 15 feet below surface level, there's 15 feet, or 12 feet, as the testimony said, that is not affected by that grouting, 12 feet of loose soil. The jury must have weighed the evidence and stated, well, we don't believe underpinning is necessary to stabilize the building, but something needs to be done to stabilize those loose near surface soils. And if we grout to 10 feet, at least the top 7, or everything below 6 or 7 feet will be stabilized. That had to be the determination, had to be the reasoning. But the jury is free to make that determination. That's why we have the jury instructions that you talked about.
Did an expert recommend underpinning?
My expert recommended compaction grouting to 10 feet and the use of underpinning. He stated that the underpinning was necessary to repair the foundation, and the grouting was necessary to stabilize the land in the building. So they must have made the determination that because the foundation didn't move that much, the underpinning wasn't necessary. Therefore, they said grouting to 10 feet.
Was the jury given, I'm looking through the verdict form, were they given an option to select underpinning?
Yes, sir.
Yes.
That was 5B. Or sorry, 5.2, they could have selected yes or no.
Oh, okay, yeah, I'm sorry, there it is, yes.
And they selected no, indicating that they didn't think underpinning was
Yeah.
necessary.
Was either expert asked about the total cost of stabilization of the land and building?
He was, Your Honor, but the entire trial, and I do a lot of sinkhole work, so I was quite familiar with citizens' argument that it has to go in the ground, it has to go in the ground. So we finally, in order to avoid them arguing the client wants a payout and not have their house fixed, we agreed that no matter what the verdict would be, we would do the repairs. So there was no need to put that number on the verdict form because my client agreed just to do the repairs, to say, we don't need to make the money argument, we're going to do the repairs.
Without regard to how this case was tried, if Citizens concedes that the fee statute applies to a deck action, when you get into this kind of dispute as to how to fix the sinkhole, wouldn't it be actually more logical to just use a deck action, find out what's the best method, and work from there?
It may have been, Your Honor. I didn't file the suit. It was filed by previous counsel. I came on in 2013.
This question probably has nothing to do with the appeal. I'm just
Yeah.
sort of...
It doesn't, but I would point out that that's not what every client wants. Sometimes clients want money damages,
Right.
and I have to disagree with Your Honor, Judge Sleet, in your decision in McKee. I think that the statute that the Supreme Court said doesn't apply to the litigation context shouldn't override centuries of contract law. If they breached, and it was a total breach, the client should be able to receive damages stemming from that breach. So that may be what the prior attorney was thinking, but that's not what the client actually wanted.
Well, this policy contains the language of 627-7075, correct?
It does, Your Honor.
So your client contracted for that
Yes, he did.
condition. So it seems to me it would apply.
Yes, Your Honor.
It's
Well,
a trigger for payment.
it's a specific performance trigger for payment had they not breached the contract beforehand. They could have insisted on it, yes. But that's not what happened in this case. They failed to raise it as an affirmative defense, and as you pointed out, Pena would allow abatement until they entered into a contract. This issue wasn't raised till well after the client had already entered into a contract, and I believe we sent a copy to them in July. I'm sorry, I had it written down, but well before, right after I got involved, we sent them a contract, and that contract was rejected. There's testimony in the record regarding that as well. If there's no other questions.
Okay.
Thank you.
60 seconds, Your Honor?
Sure.
Thank you.
Actually, you have a
Your-
couple minutes. I was going to give you 60 seconds before you sat down, and you did, so.
Okay, thank you. Your question is music to my ears, because you're absolutely correct. The proper way to handle these sinkhole cases is a declaratory relief action when it's a confirmed sinkhole. When it's a confirmed sinkhole, the insurance company wants to repair the land. The statutes are designed to repair the land, not to do, as Mr. Kling suggests, and put a check in his client's pocket. It's not a breach of contract action. This is a public safety and welfare issue. That's why the legislature enacted this scheme that controls the insurance company's hands. In this case, we complied with Florida law. We hired the engineer. We didn't second guess this engineer who said sinkhole. We said, you're right. And we sent a letter saying, please enter into a repair contract consistent with the statutorily engaged engineer. Judge Silverman, I have to answer your question because I know that it's critical to the directed verdict issue, and I respectfully know that you don't agree with the preservation. But I was reading the second affirmative defense, and it cites with specificity the statute, 627.707, and indicates that
I don't disagree
no,
with you.
okay.
Where I disagree is the statute has a number of different conditions within it, as does the policy. And your client did not raise this specific condition precedent as not having been performed.
We indicated in that second affirmative defense that the loss would be subject to payment, and specifically, we say specifically, to the extent coverage would be determined to be available under the policy, any payment for subsurface repairs would be subject to being as incurred as more fully stated by 707 subparagraph 5. When you go to subparagraph 5, it cites the holdback provision that talks about we're going to limit our payment to ACV until you enter into a repair contract. As Judge Sleet indicated, our policy incorporates, just like McKee's policy, or Tower Hill and McKee, incorporates that specific section. And lawyers practicing in Sinkhole know exactly what that affirmative defense means. It means we're going to hold back money, we're going to pay you the ACV, no contract is required for that, but we're going to hold back on subsurface until you enter into a repair contract. It was also preserved in the pretrial order where it indicates that the plaintiff's statement of the case, plaintiff contends the defendant breached, and defendant says it has not breached the insurance policy. I'm glad that counsel brought up the in consultation jury instruction because I didn't get a chance to address it. This judge in the charge conference ruled that the in consultation provision of 627.707 can give rise to a breach. But the Florida legislature, the question for this court is if we have failed to do that in consultation provision, is that a material breach of the policy? A material breach of the policy would excuse the insured's performance under the contract to repair their home. So if that's the case, a jury can say, we don't like how you consulted, so the insured gets a check. That's not what the legislature said. The legislature clarified it in 2011 and indicated it was not a substantive change, but a retroactive clarification. The in consultation meant notice. It can't constitute a breach. We ask that this court reverse and remand. You have two options, reverse and remand for entry of directed verdict in favor of citizens on the no breach. Alternatively, reverse and remand for a second trial on a pure breach of contract action, which is what the plaintiff asked for. We asked for a declaratory relief action, plaintiff objected, chose their breach of contract action. The jury instruction should have been legally correct. Thank you.
Thank you.
Next case on the docket is Peak versus American Integrity.